The future of voting rights in America hangs in the balance, and it's not looking good. The U.S. Supreme Court seems poised to deliver a devastating blow to a Voting Rights Act, the landmark legislation that has been a cornerstone of racial equality in elections for nearly 6 decades. At the heart of this battle is Section 2 of the Act, which empowers the federal government to protect voters from racial gerrymandering, a tactic historically used to dilute the political power of black communities. But here's where it gets controversial. During oral arguments in Louisiana v. Callais, the court appeared ready to strike down Section 2, effectively gutting what remains of the Voting Rights Act after years of gradual dismantling. This case stems from Louisiana's redrawing of congressional districts following the 2020 census, which revealed the state's population was 1/3 black. Despite this, the state initially approved maps with only one majority black district, rejecting 7 more racially equitable options. Voters sued, and federal courts ordered Louisiana to comply with the Voting Rights Act by creating a second majority black district, ensuring black Louisianans had an equal opportunity to elect representatives of their choice. But now a group of self-identified non-African American voters is challenging these maps, arguing that enforcing the act violates their rights under the 14th and 15th Amendments. They claim that maps designed to remedy racial discrimination against black voters actually discriminate against non-black, read white voters. And this is the part most people miss. The court seems likely to side with them. If this happens, it will mark the end of the Voting Rights Act, widely celebrated as the crowning achievement of the civil rights movement. Under Chief Justice John Roberts, the court has systematically weakened the act. In Shelby County v. Holder, 2013, the court struck down much of Section 5, which required jurisdictions with a history of racial discrimination to seek federal approval for changes to voting laws. Since then, the court has narrowed the grounds for voting rights claims and allowed states to enact laws that would have previously been deemed discriminatory. Roberts argued that racial inequality had diminished enough to render such protections unnecessary, a claim that has been starkly contradicted by reality. In the aftermath of Shelby, the gap between black and white voter participation rates grew dramatically, especially in districts previously subject to Section 5 oversight. During Wednesday's arguments, the court seemed determined to apply the same logic to Section 2. Justices Kavanaugh and Alito suggested that racial gerrymandering is justified if it's framed as partisan gerrymandering, prioritizing lawmakers' stated intentions over the discriminatory impact on voters. This flies in the face of precedent and evidence, which hold that discriminatory impact, not intent, is sufficient to prove illegal racial discrimination. Justice Ketanji Brown Jackson, a passionate advocate for the Reconstruction Amendments and civil rights legacy, voiced her frustration from the bench, emphasizing that remedies for racial discrimination are inherently tied to race. Yet, her colleagues seemed unmoved. This case reflects 2 troubling trends of the Roberts Court: its hostility toward racial justice claims, and its willingness to reinterpret civil rights law in ways that entrench, rather than challenge, historical hierarchies of race and gender. Louisiana's Attorney General, who switched sides to oppose the Voting Rights Act, absurdly claimed that assuming black voters would vote differently than white voters, which they overwhelmingly do in Louisiana, would impose a racial stereotype. This argument, though exasperating, aligns with Roberts' long-standing opposition to policies addressing racial discrimination. His infamous line, "The way to stop discriminating on the basis of race is to stop discriminating on the basis of race," ignores the systemic barriers black Americans continue to face. If the court rules in Louisiana's favor, racially gerrymandering districts to dilute black voter power will effectively become legal, while efforts to restore that power will be deemed illegal. This twisted reasoning turns the 15th Amendment on its head. The Voting Rights Act doesn't violate the 15th Amendment, it enforces it. And for 60 years it has been America's strongest claim to being a real democracy. To argue otherwise is not just bad reasoning, it's bad faith. but bad faith seems to be the court's modus operandi. A decision is expected in June, just months before the 2026 midterms. If the court rules against the Voting Rights Act, Republicans could gain as many as 19 House seats through racial gerrymandering. Is this the democracy we want? What does it say about our commitment to equality when the very laws meant to protect voting rights are dismantled under the guise of neutrality? Let's discuss, because this isn't just a legal battle, it's a fight for the soul of American democracy.